Binding arbitration and how it affects you, your health insurance, and your health care. We're all accustomed to page after page of legal jargon in every contract we sign. It doesn't make any difference if you're buying a rug, a cell phone, or health insurance, or health care from a provider. You are now faced with a mountain of words that virtually no one ever reads because it's long, drawn out, and in language that is designed to confuse and cloud what you are signing. It's also usually in small type that makes it difficult or impossible to read. The effect being most people ignore it and sign away their rights. Please take a look at this disclaimer used on the website for individual and family health insurance coverage in Pennsylvania. This is listed on Penny. In addition, I understand that if I select a health plan that uses mandatory binding arbitration to resolve disputes, I may be agreeing that any dispute between myself, my heirs, relatives, or other associated parties on the one hand, and the health plan, any contracted health care providers, administrators, or other associated parties on the other hand, including any claim for medical or hospital malpractice or relating to the coverage for or delivery of services or items, irrespective of legal theory, must be decided by binding arbitration, and I agree to give up the right to a jury trial. I understand the full arbitration provision is in and then goes on from there. But basically, and it is not, you are not looking at the contract when you sign this. When you go on Penny, or even if you sign a regular application, you may not be aware that you're giving away the rights to a jury trial if you sign the application for insurance. Now, obviously, you want the insurance. You're going to need to sign it, and it's built into that contract. It's hard to say, but you need to be aware of it. And you can ask the insurer, is that insurer using binding arbitration or not? Not all of them are. So it depends on who you're looking at. The information about the binding arbitration clause is in a document that can be found on their website and is particular to each insurer. Even if you are signing up for a plan directly through the insurer, that clause is not easily found. Why does this make a difference to you? Binding arbitration means that a private arbitrator agreed to by you and the insurer or provider is selected. There will be no jury trial. You have to wonder who is going to have more power in that selection process. This clause is stating that you give up the right to a jury trial relating to malpractice and other offenses, and so do your family members and their heirs. And it's important to realize that this can be on any insurance contract, so we really have to be careful. By signing a binding arbitration clause, you essentially waive your right to choose to go to court if something goes wrong. Encountering one of these clauses isn't necessarily a reason not to use a doctor or sign with an insurance company for a health plan that otherwise meets your needs, but it's worth understanding what binding arbitration means for you and what to look for and ask before putting pen to paper. This is a contractual agreement by which two parties, maybe more, agree to waive the opportunity to go to court and appear before a judge and jury. Instead, you resolve any dispute by a private arbitrator. And this was explained by Ramona Lampley, Associate Dean of Academic Affairs and Professor of Law at St. Mary's University School of Law. Many times, binding arbitration also prohibits multiple people from combining claims into a single lawsuit, adds Judith Resnick, professor of law at Yale Law School. So again, this is important. It's not clear how many insurers and providers make patients sign binding arbitration clauses, but experts say they're increasingly common. One likely factor is the growing number of healthcare practices owned by liability insurance providers or health systems. Binding arbitration is thought to be a way to lower providers' legal fees and reduce payouts to patients who sue for malpractice, although some legal experts argue that arbitration doesn't actually save providers money. What binding arbitration means for patients. And again, this is what's important to you. While the people or companies who own medical practices and insurers may benefit from binding arbitration, that's not necessarily the case for patients. When you use arbitration to resolve a dispute, you go before one or a panel of arbitrators instead of a judge and jury. Arbitrators might be lawyers or former judges, and they're supposed to be impartial. Most contracts designate an arbitrator. First, look to see if a reputable, unbiased service is designated, Lampley says. She advises patients to research the company that is being suggested as the arbitrator and see what their affiliations are. If the designated arbitration service doesn't seem reputable, carefully consider whether or not to sign your name. The same advice is also very important if the clause either doesn't specify who chooses the arbitrator or says something like, the arbitrator will be unilaterally selected by the drafter of the agreement. What does that mean to you? To me, it sounds like that it's whoever wrote that document is selecting the arbitrator, and you don't have a choice. If the arbitrator is a person to whom the provider regularly sends business, one might argue the arbitrator has an unconscious incentive or bias to rule in that party's favor in order to keep getting business, Lampley says. If you suspect bias, you can ask the provider to explain who the designated arbitrator is and what sort of relationship they have. Again, this means that you have to be more proactive, but it is often worth the time and effort to make sure your case is fairly treated. Arbitration tends to be quicker than a trial, but that's partly because it involves a more limited discovery process, meaning the period when a plaintiff and defendant share information that's relevant to the case. Sometimes an arbitration clause spells out the discovery rules. Other times a designated arbitrator posts the rules on their website. Yet in other instances, discovery rules aren't established until a case begins. These variations are another reason to read paperwork closely. As for the cost to patients, arbitration is often not always cheaper than going to court. In a high-damage medical malpractice case, you can find an attorney who will represent you on a contingency fee, usually 25 to 30% of your total recovery, Lampley says. So there's no out-of-pocket at the outset, and if you lose, there's no payment generally. Plus, arbitration payouts tend to be lower. On the other hand, for low-value claims that aren't worth the cost of suing in court, arbitration can provide a useful alternative pathway to recovering damages, says Lampley, adding that you often don't need a lawyer to arbitrate a claim that's only a couple of $1,000s. Lastly, many companies prefer arbitration because it shields them from public scrutiny. While some patients also see this relative privacy as a plus, others want their day in court. There is power in having a case heard by a jury, says Lampley. It's a cathartic experience. Also know that with arbitration, you have a limited right to appeal if you have any right. Knowing what you have signed and demanding clearer, less verbose, and easier to understand clauses that are stated in the beginning of any signature process may shine a light on binding arbitration clauses. Again, it's something that I feel that it's very important for you to realize. If you have questions about binding arbitration, please feel free to give me a call. My name is Susan Sloan, and I'm always here for you.